Good afternoon and welcome to our latest Posturite webinar. Thank you for joining us on, actually it's not a bad day down south. I wanted to introduce you to our presenter today, who's Adish. She has a Bachelor of Law degree from the University of Leicester. She's an employment law solicitor and has had 9 years post-qualification experience. She's been recommended for her work in the Independent Legal 500 Guide and to the UK legal profession. And she has significant experience in advising our corporate clients and senior executives on all employment law and HR matters. Now, we're lucky enough for her to be talking to us today on employment rights relating to disability. If you have any technical problems during this webinar, please remember that actually we do record all our webinars and it will be available on our website, so don't panic. So I think really without further ado, I'm going to hand over to Adish and to find out more about the employment rights relating to disability. Over to you, Adish.
Thank you, Catherine. Hello, everybody. As Catherine has said, this session relating to disability, and there is a focus with this presentation, as you will appreciate as I go through the slides, on an employer's duty to make reasonable adjustments. The reason why that is because from my experience of dealing with employment matters in the workplace and advising clients, is that quite often a claim arises where there has been a failure on the business to make adjustments, or for some reason, you know, the employee believes that in some way has led to a discriminatory kind of result for them, and often this arises with sort of either short-term or sort of long-term absences. So that's why there's a slight focus on that with this presentation. So without further ado, let's just summarise the topics that are going to be covered. The first thing is, what amounts to a disability and how can discrimination arise? What is the legal duty to make adjustments as an employer? What do you have to consider? When is the duty triggered? And what adjustments are reasonable? How far do you have to go as an employer? And then more generally, we touch upon if it all goes wrong and there is an employment tribunal claim against the business, then who's liable effectively for any alleged discrimination, and what are the compensation levels? I think it's helpful to understand that because I think it assists businesses in managing expectations and how they handle procedures, so that in the event that things don't go right, you at least have some understanding of what you may be liable for. And then finally, I will provide you with some good practice tips on how you can protect your business from avoiding sort of legal risk in the way that you manage staff and implementation of policies, training, etc. So disability is defined under the Equality Act 2010, and the definition is on my slide, which is that a person has a disability, they have a physical or mental impairment, and the impairment has a substantial and long-term adverse effect on that individual's ability to carry out normal day-to-day activities. So, as I am sure you are all aware, under the Equality Act, there are a number of protected characteristics which provide the employee with the right not to be discriminated against for that protected characteristic. And providing the individual can show that they fall within this definition, then they will be able to demonstrate that their disability is a protected characteristic, and they are automatically effectively protected if they can get over the hurdle of demonstrating this definition. just to advise you, it's quite easy to fall within this definition because it goes beyond just physical impairments and covers mental impairments. And from my experience, and it's sort of in advising clients, I think the most difficult area for businesses is dealing with mental impairment. So this is the sort of situation that we see is on the rise, which are conditions which amount to a disability that aren't sort of readily, it's not easy to identify it because you can't see it. And you know, when we talk about mental impairment, we're talking about things like depression, stress, you know, manifestations, you know, of potential bullying in the workplace. You know, upon an employee joining, they may have it, or it may turn up as a result of being in the workplace. It's really about understanding, you know, if anybody in the business is suffering from these things, to make sure that you understand if they fall within the definition. And we'll come on to that a bit later on. I've highlighted an area which is relatively new in the field of disability discrimination, and that's the issue of obesity. The new EU case of Kaltoft has basically handed down a decision to state that obesity may be a disability where it entails a limitation resulting in the individual from having a long-term physical, mental, or psychological impairment, which in interaction with various barriers may hinder the full and effective participation in professional life. I just wanted to highlight this for you because it's not something that has come up in the course of my working practice too much, but recently I've seen it come up. So I think as a result of this decision, the Employment Tribunal will have to deal with this. I think more individuals are going to claim this as a disability. So it's something certainly to watch out for, and it just illustrates my point that it is very easy to fall within this definition now. One other thing, sort of in terms of breaking down this definition, a long-term adverse effect, as long as it means, basically, as derived from case law, that as long as an individual can show that their condition has either lasted 12 months or is likely to last 12 months, then they would satisfy that part of the definition. So if somebody's got, you know, diagnosed with a condition which has only been around for 3 months, that doesn't mean to say that you can discount them for disability because it's not long term, because providing they can show with medical evidence that that could well last 12 months, then they are caught within this definition. In terms of normal day-to-day activities, we would, you consider activities in the home environment and in the work environment as well. So that's the definition of a disability. In terms of sort of who has the right within a business out of your staff, the people that you work with, who has this protection afforded under the Equality Act? Well, it covers right from the outset people that don't even work for you. So job applicants in the recruitment process, for example. It covers then employees, so people that are actually engaged by you, former employees who perhaps may claim post-termination discrimination, and there's a case that I'll be dealing with which highlights that. Office holders, contract workers have the right to not be discriminated against, and recent cases have shown that LLP members, so of a law firm or an accountancy practice, for example, who are partners, may also be caught within this Equality Act. The protected employment areas within a business, so in the areas that I'm about to discuss with you, an individual has the right not to suffer discrimination. So that is the recruitment process. So the way in which the individual is, right from the beginning, the advert, the process for selection for interview, the way in which the interview is conducted, the selection post-interview, and then in terms of the offer that is made, how that is made, pre-employment health questions will be covered, so that you can only ask pre-employment health questions once an offer of employment has been made and not in the process before, unless the job requires an adjustment specifically. So for example, if there is a lot of heavy lifting, you may want to ask in the process that somebody's physically able to do that, because you're basically looking out for them. But there are very limited circumstances in which you can do that. Pay and benefits, so the way in which you administer pay within the business, between those who are suffering from a disability and those who do not. Benefits, so that private health cover, bonuses, commissions, that kind of thing. So if somebody's been off sick on long-term absence, or maybe they're off persistently on short-term absences, for example, you need to think about ways in which you deal with pay rises and potential benefits to ensure that somebody isn't suffering because of their time out of the business because they have a disability, because they will argue that that's not their fault to have that time away from the business, and that they should therefore not be suffering any discrimination in the form of underpayment or benefits in comparison to their non-disabled colleagues as a result. Same applies in terms of promotion. People that are getting promoted and those that are not. The application of policies, and when I say policies, I mean those that are contractual, so things that are typically in a contract of employment and are fundamental terms of employment, and also those that are non-contractual. Non-contractual policies we would typically see in a staff handbook, for example, things relating to the sickness absence policy can be non-contractual. The way that managers deal with performance and absence management, have to watch out to make sure that's not discriminatory in any way. So for instance, if you have any suspicion or you've been made aware that a decline in performance is in some way linked to ill health, then any performance procedure would have to be adjusted accordingly within what would be deemed reasonable. The same with handling any absence from the business. An employee has the right not to suffer dismissal effectively as a result of any form of discrimination or because they have a disability. And then there are post-termination sort of protected areas as well. Situations where this may turn up are, for example, the way in which a business gives a reference about somebody. You don't have to give a reference, there's no legal duty to do so, but if your policy is generally to give a reference and not just limited to a standard one, you might want to watch out for what managers, etc., are saying about staff that have left the business, if there's been some sort of friction relating to any sort of sickness absence, that kind of thing. So moving on to the next slide, as I said to you, there's a slight angle here on the legal duty to make adjustments, because this is often where this is almost the catalyst for employees often claiming that they've suffered disability discrimination because they feel that they've raised an issue and that appropriate adjustments just haven't been made. So what is that legal duty? Well, the legal duty to make adjustments is that if there's a provision, a criteria or a practice within the business which puts a disabled person at a substantial disadvantage in relation to a relevant matter in comparison with persons who are not disabled, then the employer has to take steps that are reasonable to avoid that disadvantage from happening. And on the next slide, I'll go into that definition in a bit more detail. the adjustment duty arises where there's a physical feature that puts disabled people at a substantial disadvantage. We don't focus on that in this seminar. And a disabled person would, but for the provision of an auxiliary aid, be put at a disadvantage. You would need to consider adjustments in those circumstances. So then, what triggers the duty to make adjustments? So you have somebody within the business, they've informed you that, you know, whether at the outset and after they've been hired or during the course of their employment, they've developed a disability, and they inform you about this, you know, and they want sort of some adjustments to be made. When does the duty effectively trigger? Well, it triggers if as an employer you know, or you ought reasonably to know, that the person has a disability or is likely to be put at a substantial disadvantage. An employer won't avoid the duty to make adjustments where they didn't know but should reasonably ought to have known about that individual's disability. So what are the things to look out for here? Well, the tribunal says that, for example, if you have agents working for you and they are made aware of somebody's disability, then in some ways you are deemed to have knowledge as well. That's just an example. There are also alarm bells that can start ringing, you know, with those that manage staff or with HR, you know, who typically deal with these issues, where, you know, you get warning signs from an individual in those circumstances. Don't ignore them, because that may be the first thing that somebody will rely on. Say, well, you know, based on what I said or what I did that day, then you ought reasonably to have known that I was suffering, and you should have done something, you know, about it. There's a case, Department of Work and Pensions and Hall, it's an employment appeal tribunal decision, where the tribunal held that Ms Hall's negative replies in a health declaration form, her refusal to let her employer have access to her medical records, and her volatile behaviour should have been a warning sign for the employer that she was suffering from a disability. In addition to that, a member of the interview panel that recruited Ms Hall knew her previously, but did not mention anything about her health or disability to the other managers during that process. So I think in those circumstances, an employer would have been perfectly within its rights to have made reasonable further inquiries in order to ascertain whether or not that person was in fact suffering or not. So there are, you know, alarm bells that can ring, and my advice would be, if they do, don't be afraid to sort of have a consultation and make reasonable investigations in those circumstances. In terms of, you know, a provision, criteria or practice within the business which puts somebody at a disadvantage, there's a code of practice on this which you can obtain from the ACAS website, which states that the provision, criteria or practice should be construed widely to include both policies that are verbal and in writing. In every business, things can evolve, a rule, a practice, which necessarily doesn't make its way into written form, but also written policies, be anything formal or informal, rules, practices, arrangements, qualifications, including even one-off decisions and actions, discretionary decisions, criteria and arrangements for selection of employment, training, promotion, terms of employment, working conditions, grievance and disciplinary policies and procedures. In essence, what you're trying to do is identify whatever it is making that disabled person's ability to carry out their job impossible or unusually difficult, as they might allege. So that's the provision, criteria and practice element of it. And then in terms of, you know, showing that there has been some sort of, there should be a duty to make adjustments effectively to avoid any sort of discrimination, the individual would have to show that they are suffering some sort of substantial disadvantage. Note the word there, substantial. Well, again, the Code of Practice gives us some guidance on this and what this means, and it states that substantial disadvantage is in comparison with persons who are not disabled, and defines it as a disadvantage which is more than minor or indeed trivial. A substantial disadvantage, for example, can include being exposed to the risk of dismissal or other detriment. And, again, generally my advice is that this is quite wide and generally an area which individuals can readily sort of establish if they feel that sort of something's not being done which they think is going to lead to a discrimination claim. In terms of long-term absence, I have a lot of clients who raise this as a concern. What do we do with the long-term sick within the business? Well, there's a recent case that's come out, which is Duran and Department for Work and Pensions 2015, which states that actually the adjustments duty isn't triggered for the business where the employee on long-term sickness leave remains unfit for work and has given the business no indication whatsoever of when they might return. So the onus there would be on the employee to discuss arrangements for a phased return. Whilst this case is helpful for employers, in actual practice, my view is treat it with caution because, in reality, there is some indication as to when that person is going to be returning in the form of a sick note or indeed occupational health advice, albeit that information is often inaccurate because it changes. 1 minute they're off sick for 6 weeks, then it leads to 4 months, then it can go on to 8 months. But if there is actually no prospect, of when that person is going to remain fit for work, then a duty is not automatically triggered. What my advice is in those circumstances, however, is don't just listen to the GP. If someone's been off for a month or more, get them to occupational health and get an opinion so you can always rely on that. Employers really shouldn't be looking to terminate employment unless there's medical opinion, from a person qualified in that particular condition, so not a GP, but a consultant or occupational health who says, what, this person is actually unlikely to come back for 6 months to a year, and in those circumstances you can really look at whether you can reasonably be expected to keep that job open. But unless you've had that opinion, and as long as there remains a possibility that somebody is likely to return within 2, 3, 4, even 5 months, then termination really should be the last thing on the agenda, and what you should really be focusing on in those circumstances where there is a sort of foreseeable return is whether you can get them back in on a phased, or indeed, what can you be doing to get them reintegrated back in. Rather unhelpfully, an employee doesn't have a duty to disclose the fact that they have a disability to the business. But of course, if they have to fill out a questionnaire upon joining, which a lot of employers now do, which is after the offer of employment's been made, is that if they, have dyslexia or have suffered from stress or, have had cancer or, are having ongoing treatment or have had a knee injury and, the effects of that is ongoing, and they don't, or even arthritis, something like that which affects their working life, and they actually fail to disclose that on a form, then they later seek to rely upon it to say that actually, you haven't been helping me. You misrepresented us when we recruited you because you didn't disclose this. If you can show that there's been misrepresentation, you can protect yourself. But again, it goes back to that point about, ought you reasonably to have known as an employer that that person was suffering from a disability. I would suggest that there are often signs available if managers are, line managers, HR are trained in spotting this. And at that point, my advice is just to speak to them about it informally. Do you need us to do anything? Just have a sort of two-way communication in that situation, really to assist you. So we talk generally about what is reasonable in terms of adjustments, and then more broadly, in terms of trying to show as an employee that you have rights not to be discriminated against. What is an employee likely to allege if they raise a grievance or they go to a tribunal in terms of what they thought would have been reasonable? So in terms of determining what is reasonable, it's important to identify whether or not a step taken in the form of an adjustment would be effective in alleviating that disadvantage. I had a case that I dealt with once where the individual worked at an NHS trust 50 minutes away from her home, and she wanted to move to an NHS trust that was nearer. And notwithstanding the fact that there actually wasn't a role available at the nearer trust, the employer, following medical advice, said that actually moving the individual closer to work wouldn't alleviate the disadvantage suffered by her in travelling, because it wasn't about the distance that she was travelling. Her issues were much broader than that, travelling being one of them. So actually, that wouldn't have been a reasonable and effective adjustment. I mentioned earlier in this presentation that the duty to not discriminate extends beyond termination of employment. I gave the providing of a reference as one example. Another falls within the arena of making reasonable adjustments. The case of Hinsley and Chief Constable of West Mercia Constabulary illustrates this perfectly. In this case, Mrs. Hinsley, a probationary police officer, resigned, and within weeks of resigning and her resignation having been accepted by the police force that she was working for, she was diagnosed with stress and depression. A few months later, she went back to them and said, I actually made a mistake. I wasn't feeling well at the time. I had a disability. Can you please reinstate me because I made the wrong decision? The constabulary said that they were not under an obligation to reinstate her because the provision criteria in practice was that police officers who had retired couldn't be reinstated. The substantial disadvantage suffered by a person with mental illness is that a decision to resign is more likely to be taken on irrational grounds, which is what the Employment Appeal Tribunal found. And on those facts, the Employment Appeal Tribunal found that the constabulary were wrong to say that their policy was that they couldn't reinstate, and that they should have, in light of that disability, considered reinstating her. So that's where an adjustment might turn up post-termination. Another thing to bear in mind in order to limit the risk of discrimination claims for disability are to think about adjustments to any sort of absence policies that you may have as a business. There are some businesses that I have worked with who have a system whereby if you are sick for a certain number of days in any given period, usually a year, then disciplinary action is taken and or it gives rise to the right to terminate. Exercise these clauses with caution in the case of individuals suffering with a disability, because they will likelihood succeed in arguing that actually the absence that they are suffering is not their fault because their disability prevents them from getting into work, and that they shouldn't be penalised by disciplinary warnings or indeed termination. Every case will be based on its facts, but just sort of be careful and seek legal advice when you are faced with dealing with that situation. The Code of Practice gives a good list of adjustments that an employer should be considering and what is considered reasonable. I would encourage you to read that. And there are some cases which are of particular interest, I think, in terms of giving you an idea as to you know, what the tribunal's been finding in terms of what is and isn't reasonable, and I've listed 5 on the slide there, just to take you to a couple. Secretary of State for Work and Pensions and Higgins. This was a good case for employers because the tribunal held that the phased return that was agreed for the employee of 13 weeks was reasonable, and that the assertion that this should be extended beyond that period wouldn't have amounted to a reasonable adjustment, because actually it was found that the hours that that person was doing within the 13-week period wasn't putting them at a substantial disadvantage, and there was no consideration in fact given as to whether or not extending it beyond the agreed 13-week period would have alleviated the substantial disadvantage caused by effectively you know, keeping it as it is or extending it. In the case of Fuller, the individual here suffered from asthma and wanted to be kept away from windows open and drafts. This caused problems for the rest of the business because employees were feeling sort of suffocated and needed some fresh air. So the employer tried to accommodate the individual by moving her around the office, hot desking, even relocating to another office. She resigned and claimed disability discrimination and lost her case. It was held there that the employer had done what it could do in the circumstances. In Crossbets Limited and Others and Butcher, not so good for employers, in that case it was held that an employer should, in certain circumstances, and again, this is very fact sensitive and I would encourage you to read this case, but an employer should in certain circumstances consider private medical treatment in the form of counselling that it would pay for in order to support an individual suffering with a mental impairment. The prevailing point in this case was that the employee could show that actually the mental health problems that she was suffering from were related to her working environment and the way that she had been treated, and I think that was compelling for the tribunal in that case to determine that actually the employer should have offered to pay for some counselling in those circumstances. So it's interesting to see whether, if in a case where the employer doesn't necessarily contribute to that illness, whether there would still be such a finding. Again, if you are faced with such a situation, then I would recommend that you seek legal advice. So in terms of dealing with sort of disability issues that arise in the workplace, it can sort of be difficult for businesses to manage in a few ways. The first and most obvious way is if the individual wants to pursue a claim in the employment tribunal, so actually goes to the trouble of litigation. That can be very expensive. But as I'm sure you are all aware, there's been a reduction in tribunal claims generally because it's expensive now for individuals to litigate. It costs around £1,000 just to get a hearing, and that includes the cost of submitting a tribunal claim form. But on the other hand, unfair dismissal claims have also been made more difficult to pursue because now you need 2 years service and compensation is capped at 1 year's salary. So what individuals are doing is looking at other claims such as discrimination, whereby the compensation that you can get can be a lot higher because it's uncapped. So although there's a general decline in claims, more people are focusing on discrimination as a way in which to pursue claims. But it's not just about claims, is it? It's more, the management time in dealing with someone who suffers from a disability, providing cover when there's an absence issue, sort of work morale, the impact on other members of the team, management time and expense in dealing with it, the cost of seeking medical opinion. So there are a lot of costs and things to the business which I think most employers would like to avoid actually. So it's not just about trying to find a way to stop a claim from arising. It's actually just having good practices in place to mitigate the effects of, you know, a disability and what that can mean for a business. If somebody pursues a claim for disability discrimination, then they are likely to couple it with other claims which they may raise in the form of a grievance in the first instance. So, for example, a constructive dismissal claim, if they feel that, you know, they've made complaints of discrimination in the business, that their manager has sort of said nasty things to them, there haven't been adjustments, or indeed that they've been discriminated for whatever other reason on the grounds of their disability, then they could also argue, if nothing has been done to support them, that there's been a breakdown of trust and confidence, entitling them to resign and to blame the employer for that, which gives rise to a claim for constructive dismissal. An employer will be vicariously liable for the actions of its staff, so you will pick up the bill, but individuals can be sued personally in the employment tribunal. So if a manager is making decisions and it's the manager that the individual has an issue with, just as an example, then they can be sued personally. And I would hold, you know, as a business training session to get this point across to assist everybody in the business in terms of highlighting issues. Please do use your equal opportunities policy, disciplinary and grievance procedures in the most appropriate way to protect the business. What that means is that if, for example, an individual makes a claim for discrimination in the form of a grievance or informally, you know, and actually after a reasonable investigation there is a finding that there has in fact been some form of discrimination, you know, please do consider taking disciplinary action against the perpetrator, because that shows the business that you're taking the matter seriously and that you're taking steps as a business to reduce any effects of discrimination, and that you are actually making use of your policies rather than them sort of sitting on a shelf gathering dust. If anything escalates to a tribunal, one of the first things that you'd be asked is, you know, what are your policies on anti-discrimination and how have you used them appropriately? It's really important to train your managers on that and actually use them. If it goes to an employment tribunal, then an employee can get compensation for lost income. So as a result of any resignation or dismissal where they can find that that's discriminatory, or if they've suffered discrimination in the form of a lack of promotion, for example, it would be the lost income of the new role if there would have been a pay rise attached, if they feel that that has been a discriminatory decision. For instance, they've been off sick for longer during that year so they didn't get the same opportunities, or they have a disability so they're deemed in some way to not be as worthy for the new role as somebody who's not disabled. Or, for example, if you're carrying a redundancy exercise, you know, it's about trying to find ways in which not to penalise people who have a disability and any related absence. There's a separate tranche of compensation in the form of injury to feelings. There are bans for this. Case law sets down sort of limits, but really, you know, it can be, there is no limit, and it depends on the gravity of the situation and how bad the discrimination is. But generally, compensation for disability discrimination is uncapped. So just finally, how can you reduce the legal risks to your business when you're dealing with disability within the business, whether it's in the recruitment process or sort of right at the end towards termination and during the life of the employment contract? As a business, please encourage employee disclosure, open communication, informal reviews is always very helpful, and make sure that you take a note of all meetings so that you can use that as backup for evidence. Consult with your staff and employees who are suffering from illnesses, and actually ask them for suggestions, ways in which they feel you can support them, because that will look really good for you if that goes to an employment tribunal, or if you're trying to defend the business when a grievance is raised, because it shows that you're actually having a meaningful discussion and haven't made a predetermined outcome. That would be very helpful in defending any claims. Seek occupational health advice and also legal advice at an early stage, because if the situation can be diffused earlier, then it's likely to be less costly and time-consuming for the business and management. Also consider expert independent opinion. So if somebody suffers from, diabetes or some sort of bone condition, and beyond occupational health expertise, there is nothing preventing you as a business from incurring the cost of going to the expert in terms of understanding what you can do for that individual. Consult and document everything. Hold training sessions as much as you reasonably can to train everybody who deals with these issues. And I would suggest sort of training managers on diversity issues more broadly outside of disability discrimination, because they tend to in some way connect. In your contracts, if you want to limit long of absences, I would encourage the use of using statutory sick pay as a tool as opposed to having paid sick leave. That often helps. And if it gets to the stage where you need to terminate, then always seek fresh medical opinion and legal advice before terminating or varying anybody's terms, because things can change and it's always good to get fresh advice that you can rely on. So that's the end of the presentation on employees' rights relating to disability. And I hope you have enjoyed the session. Thank you very much.